to the House.
The Honourable Leanne Dalzell.
Mr Speaker, I'm actually very grateful to that member for his contribution to this debate, because he's actually spelt out in his contribution exactly why the top priority for this government in this area should have been the Alcohol Law Reform Bill, and why this won't make the extent of difference that it could make if in fact it was extended to first responders such as nurses in our emergency department and other staff in that area. But more importantly, and one that hasn't been mentioned yet, our ambulance officers. They too are confronted with a situation, and yes, they may call the police, but the purpose of this is actually to state the abhorrence, as the member said, of the act of taking action against or committing a criminal act against an individual who's acting in the course of their duty. And a first responder in an accident situation will in fact be an ambulance officer. More often than not, they will be there before the police are there, and they are the ones who are subjected to outrageous attacks on occasions as well. And if the purpose of this legislation is, as the member said, and I think this is the purpose of the legislation, it is not to act as a deterrent and thereby potentially reduce the number of assaults on anyone concerned. It is designed simply to state this Parliament's abhorrence of such attacks being made on people in those positions. There's no reason not to include people who work for our ambulance services and people who work at the front line of our health services, where they're much more likely to come into contact with this kind of behaviour than any other group, other than obviously the police and the corrections officers themselves. So I think it would be a very good thing for us to expand this. Now, I did see the Select Committee considered this as an issue, and their response to it was that they should, that the bill itself was to recognise the legal obligation as first responders to dangerous situations. Well, I actually think that that language applies equally to our ambulance officers in particular, but emergency staff at our emergency departments as well. The other thing that I would just mention in relation to this is that when the Select Committee looked at this, they felt that there was potentially a problem with the scope of the legislation and whether there was sufficient scope in the purpose of the law to recommend an amendment to extend it beyond that. And I think the solution to that lies in this House, because of course when it comes to the committee stages, it would be very easy for the Minister to move or to seek leave of the House that any out-of-scope amendments extending the coverage of the legislation could be dealt with at the committee stages of the House. And I certainly could speak for the Labor opposition in saying that we would be very amenable to such an amendment. I think it would send a very powerful message that the House took that approach to our ambulance officers and to other staff as well. And if it genuinely is the reason, the reason is that the Select Committee felt that it couldn't go beyond the scope of the legislation as introduced, well then the remedy lies in the House's hands, and that's something that I would ask the Minister to perhaps look at over the next wee while before we get to the committee stages of the bill. The second issue that was looked at the Select Committee was the question of creating a reciprocal aggravating factor. Now, I actually agree with the position that the Select Committee came to on this. I think that the purpose of the legislation and sending a message in terms of how we feel about this kind of behaviour, that in itself, I don't think it is appropriate to reverse the obligation when that obligation already exists in fact. So I do believe that the Select Committee came to the right point on that. Now I want to turn to the regulatory impact statement. Those of you who know me know that I love regulatory impact statements. I think they are the most important part of the legislative process. I have been working very hard on ensuring that we have a really good process around regulatory impact statements, and I know a good regulatory impact statement when I see one, and I know a very poor one when I see one. I'm sorry, this one fits into the very poor category. But that's because of the brief that the officials were given. And I'll just run through the regulatory impact statement because I noticed some new members in the House, so they won't have heard my speech before, and so they will be invigorated by it, absolutely. And so my normal speech goes something like this. The purpose of the regulatory impact analysis is to, 1, state the problem. Number 2, identify all of the options for addressing the problem. 3, undertake detailed analysis, and that means risk, opportunity, cost, and benefit. So you really have to undertake the analysis with all of the options on the table, consult with relevant stakeholders, and then recommend a particular course of action. And then the final point, which often people don't always remember, is to follow it up with a process for the analysis of the efficacy of what you've done, so that you're actually looking back over a period of time, seeing how the change has actually implemented. Now, that is a very good process. Unfortunately, this hasn't done any of them. So, except for stating the problem and the solution in one sentence, which is there has been an increase in the number of assaults on police officers and prison officers over the past 5 years, and a spate of serious incidents in recent months. Therefore, the government has decided that the Sentencing Act 2002 should be amended to ensure that the fact that an offence is committed against a law enforcement officer will be taken into account as an aggravating factor at sentencing. So all of the in-between steps have been left out of the process, and that final one about analysis of its impact afterwards, it says here, because judges' assessment of aggravating and mitigating factors are not amenable to empirical analysis, and the proposed amendment does not entail specific action by the court, no monitoring or evaluation of the proposed amendment is possible. It's not even difficult, it's just not possible. So it fails on that final point as well. So we've had a statement of the problem, straight to the solution, and unfortunately I think we've missed a bit of an opportunity to do something a little bit more than this, because I'm not opposed to the concept of setting out in the Sentencing Act another aggravating feature. I'm not at all. But I don't want anyone to think that the aggravating features in the Sentencing Act are in any way a method by which we reduce the offending concern, because in actual fact it doesn't work like that. Usually when we're talking about assaults, we're talking about things that are in the spur of the moment. We've heard of alcohol involvement, which is why I think the alcohol reform bill would have been a better priority to be dealing with tonight. And so there aren't any occasions that I can think of in people in those circumstances when they're engaged in an assault that they sort of go, gee, I wonder what sentence I'll get for this if I get caught, you know, and that's the problem with the concept of it not reducing the problem. So I think there has to be more than this. It can't just be this to deal with the underlying issue. So when we look at how the High Court regards assaults on police officers, again, the regulatory impact statement is a great source of valuable information. And this is how the High Court has described an attack on a police officer. The High Court has said it is the equivalent to an attack on the community because our police are the representatives of the community in the matter of law and order in society. They are society's front line. And so the Court of Appeal there was emphasising the gravity of using serious violence against police officers and was upholding deterrent sentences in a number of cases. So that was on an ongoing basis. That case dated back to 1985. So if we'd had the problem definition and the analysis done in between, then we might have actually identified that in fact the law already allows the court to take this matter into account, and they usually do. And in fact, that's been the problem of the process, is that nobody has in fact identified for us when they didn't take it into account or if they allow the mitigating factor that this wouldn't allow, because this does allow mitigating factors still. It is only one of the aggravating factors to be considered, and that's why it's very difficult to monitor. So I think that this whole legislation could have been improved, and it can still be
Sorry to
improved.
interrupt the honourable member. Her time has expired. Call David Clendon.
Thank you, Mr Speaker. I'm pleased to speak to this bill for the first time.